So I'll now formally begin. Welcome and thank you so much for joining our webinar, Renting and the Law. I'm joining today from Gadigal land and I pay my respects to elders past and present. As we come together for the purpose of legal education, may we also acknowledge Aboriginal and Torres Strait Islander people as the first educators, storytellers and lawmakers across the lands that we're all joining from. This webinar is part of our Lunch and the Law series for New South Wales Law Week. Law Week is an annual festival all about creating greater access to justice. And this series aims to demystify the law and empower people to understand their legal rights. So what better way to do that today than to have the Tenants Union join us for this week that's being described as one of the biggest weeks of rental reform in a generation. So this week's part of a series of reforms that has been happening in New South Wales since last year, I believe, and is ongoing as well. So there'll be more changes later on in the year, and the Tenants Union will tell you all about those changes today. Law Week is supported by Legal Aid New South Wales, the Tenants Union, Marrickville Legal Centre, and New South Wales Libraries Find Legal Answers. So if you are joining from a library today, big shout out and thank you to the libraries who are live streaming this event. As a reminder, we'll be talking about New South Wales law. So if you have joined from another state or territory, the laws will likely be different. This presentation is general information only. It can't be relied on as legal advice. Everyone's situation is different, and we'll be able to give you some contact information at the end of this webinar as well if you do need advice about your particular situation. So I'll now pass it on to our amazing speakers. Grant Arbuthnot, who's the Principal Solicitor at the Tenants Union of New South Wales, and Charlie Wild, the Community Legal Education Coordinator. And a massive, massive thanks to the Tenants Union, who've not only been a part of these huge reforms, but have also played a huge role in education and informing the public about what the laws are and that people's legal rights. So thank you so much, Charlie. I'll pass it over to you.
Thanks, Yasmin, and nice to be with you all today. A little word on who the Tenants Union is. The Tenants Union is a specialist community legal centre. We specialise in tenancy law. And in addition to our legal work, we advocate for policy change, we produce resources for renters, and we provide the community with education about tenancy. Grant, you're the Tenants Union's principal solicitor. Can you tell us a little bit about your experience in tenancy law? He will in just one moment, folks.
That's better. Yes, I've been working in tenancy-related jobs since 1995. I've been principal at the Tenants Union since 2002. So I've been around too long.
Yeah, and we've got a wealth of experience to draw on today in all of your questions that you might have. Today we'll be running the session as a Q&A style. So I'll be asking questions and Grant has the job of answering those questions. But you've probably heard we've just had a range of law reforms in New South Wales. Today we're going to focus on those changes. So we're going to look at the new laws on terminations, also known as evictions. We're going to look at changes to rent increases. We'll have a look at pets. We'll talk about water efficiency requirements that have now come into place, the fee-free ways that renters are required to have to pay rent, and the ban on charges for background checks. We'll also be talking about where to go for help if you're confused about the new laws or how they apply to your situation. So we can see we've got all of these reforms, Grant. Can you give us an idea as to the background of these reforms? Like, why were they needed?
No grounds eviction is where a landlord doesn't have to give a reason. to terminate a tenancy. And what it meant for tenants is that they were always on probation. And many tenants were afraid to, for example, ask for repairs to the premises because they expected they would get a no grounds termination notice, either at the end of their fixed term or at immediately, because they asked for the landlord to perform the contract.
Yeah, so whether these changes are successful in addressing those concerns remains to be seen, but we're hopeful that they'll at least assist the process. There've been long fought for changes, and we're looking forward to seeing those changes roll out. So we'll go through those big changes shortly, but before we do, Grant, we had a question from one of the registrants about whether these changes apply also to people living in social and affordable housing. Do these changes apply to those tenants as well?
Yes, they do. Where something doesn't apply to social and affordable housing, well, social housing, it usually says so in the Act. So yeah, I think all of this is going to apply. Although it was quite uncommon for social housing providers to use no grounds termination notices, and that was both a matter of law and then a matter of policy.
Right. So now that we don't have no grounds evictions, I suppose that means we have grounds evictions, right? We need reasons.
Yes, and the Act now has a suite of grounds that landlords may use in their circumstances to end the agreement.
Fantastic. And I'll ask you about those shortly. But just so we're clear, as of yesterday, the 19th of May, landlords need a valid reason to evict someone. What if someone
Yes.
received a notice on the 18th of May or just before these provisions have taken effect? Is that eviction notice valid?
Yes, and it will be treated as though the old law still applies, so that existing termination notices at midnight Sunday will be treated as though the changes did not happen.
That's been the unfortunate case of one of the members of the audience. In terms of contesting that old eviction notice, then what law applies?
If it's an end of fixed term notice or a no grounds notice in a periodic agreement, then the Act said, and for those people still says, the tribunal must terminate the tenancy and make it a possession order. So there's no discretion to not evict if the paperwork is done properly.
Okay, so it's about checking if all those T's are crossed and
Yep.
dotted.
And the tribunal has discretion to waive defects in termination notices. So it's possible for the notice to have problems and you still get evicted.
All right. Okay, so dealing with the law as it is today, what are the reasons that a landlord can use to end a tenancy? And I understand some of the old reasons to end a tenancy still apply. So maybe we can start with those old reasons, Grant.
Yeah, well, breach of contract, including rent arrears, is still there. And so is actual sale of the premises. Can still be grounds for termination. And there's still there's sections in the Act that don't require termination notices about illegal use of premises, about uninhabitability of premises, undue hardship can be a tribunal application for termination.
Okay. And along with those older reasons that still apply now, there was that suite of new reasons that have come into place. Can you tell us about those new reasons?
Yeah, so adding to actual sale, there's an intention to sell. ground, and other grounds like a family member will move in, the premises are going to be demolished, the premises need extensive renovation or repair, and there's a couple of social housing ones. So the tenant losing their eligibility for transitional housing or affordable housing. There's also one about key worker housing projects as well, and student accommodation.
Right. So if you're no longer a student, then you're no longer eligible for student housing.
Yes, and the landlord can give a termination notice on that basis.
Okay. Grant, that's a lot of new reasons. Here's a question, though, that we get quite a bit. What's to stop a landlord just giving someone a fake reason to evict them, like just making something up?
There are requirements for evidence to be provided with termination notices, and there are penalties for non-genuine grounds, and there are also what we're calling no relet periods, so that if you give a notice on a particular ground and then you change your mind, then you can't relet the place for 4 weeks or 6 months or 12 months, although the Secretary of Fair Trading can license premature reletting if that person applies.
Okay, like before we talk about the reletting, let's go back to the proof. If I'm a renter and I've been given a notice of termination for a reason, where can I go to find out what proof the landlord needs to give me?
Well, it's in the legislation, but it's also on Fair Trading's website. So that's Fair Trading New South Wales, and it's on the Tenants Union's website. We've got all of the new law is now up on our website, which is tenants.org.au.
Okay, thank you. I've noticed there's one question here that I wanted to ask you about. It says, does no longer rented out cover the conversion of a long-term rental property to a short-term rental? For example, can your landlord boot you out to turn the place into an Airbnb on the ground that it won't any longer be used as a residential rental?
Yes, under the new provisions, that counts as a change of use. And the evidence requirement for that is a statement from the landlord and proof of registration on the short-term rental accommodation register.
Okay. Okay. Thank you, Grant. There were a few questions about that, so I'm really glad you could answer that. So the kind of proof you might require varies depending on the type of termination notice you've been given, but you can
Yes.
find out where that proof is by going to our website, tenants.org.au.
Yes.
There. Now, you mentioned no relet periods. I think we had a slide to do with that set out those no relet periods. If we could just flick over to that. So the no relet period, as you're mentioning, is a period of time which the landlord's barred from renting out the property again to someone else. Is that right?
Yep.
Yeah. Okay. We've got this handy table up on the screen, as you can see, and it sets out how long the landlord's banned from reletting the rental period, rental property for, based on the reason that they've given. So that's a handy guide, but as we say, we'll be updating our resources to make this situation easier for people to work through. Okay, so let's put this in context and talk about a more real world example. Dave was given a termination notice because the landlord's parents want to move in. He thinks the landlord's just making it up to kick him out. What advice would you give Dave, right?
I would say to Dave, notice of termination doesn't end your tenancy contract. It either ends by notice of termination and you giving possession of the premises to the landlord, or notice of termination and the tribunal making an order. And then I would ask Dave about the documents he's received to see what the evidence is, and we would then compare the evidence with what's required by the Tenancies Act for that ground.
Is there any other recourse that Dave might have if he thinks that things are a bit suspicious?
He could do research to see if the factual claims made are true or not.
Oh, right. Okay. There was a question from the audience about seeking clarity about the end of no grounds terminations and asking if this applies in transitional housing too. Maybe this is a good chance to address that. So say you're at the end of a fixed term lease. Is that
Yes.
in transitional housing?
Yeah, so transitional housing landlords are usually community housing providers, and they will no longer be able to use an end of fixed term notice, which is a no grounds notice. However, the ground for termination is about losing your eligibility for transitional housing. And so if your eligibility ends just by the passing of time, then a notice of termination could be valid for the ground that you're no longer eligible to be in that housing scheme.
Okay. One more question about terminations before we move on to the next topic. We've got one in the audience. It says, does termination of contract include if a tenant's been incarcerated and arrested? And what if arrest papers haven't been released yet?
Being arrested and going into custody do not end your tenancy agreement. The tenancy still has to be ended according to the residential tenancy agreement. And I think quite often in the private tenancy market, unless there are other people who are living there as members of the household, landlords just think people have abandoned the premises and take possession. In social housing, the landlord is likely to act on illegal use of the premises, or if you're in custody for a while, they will ask you to surrender the tenancy because you're not going to be able to make use of the premises. But there's a lot to be done when somebody goes into custody if they're in social housing, especially if there are other members of the household who need to be housed.
Okay, thanks, Grant. That's helpful. Another one on termination. Does the evidence supporting the notice of termination need to be given at the exact same time as the notice is given?
Yes, it is to be given served with the notice. There should be at least 3 documents where evidence is required. One is the termination notice. There's another one called the termination information statement, and the third one will be an evidence document.
Okay, thanks, Grant. We're also seeing a few questions about the end of fixed term agreements, say a 6-month agreement or a shorter agreement. Can rental contracts still end at the end of that 6-month period, or will they all be ongoing leases now?
If they don't automatically, they just automatically become periodic agreements if nothing else happens. So if there was a termination notice from the tenant and the tenant moves out and gives possession, then that's going to terminate the agreement. If the landlord has a ground and gives a termination notice based on that ground, then it can terminate that way, either by the giving of possession or by tribunal order. So that's not changing. In our Tenancies Act, there is no such thing as what lawyers call holding over at the end of a lease. What happens is a fixed term agreement automatically becomes a periodic agreement, and the rules are nearly all the same. There's just some changes about rent increases and termination notices.
Okay. Thanks, Grant. Let me just see if there's another one there. I've got one here. Is there any provision relating to the first fixed term, like in some other states, or does this apply from the first fixed term? I think that might be referring to a short term, a 6-month agreement, and then another 6-month agreement following.
That makes it, yeah. The changes invent a new creature in New South Wales tenancy law that is a fixed term of 6 months or less, and that changes the notice periods for the new grounds. It doesn't change the notice periods for the old grounds like breach.
All right, let's move on. We'll talk about rent increases now. We had a question from the audience. The new legislation limits rent increases to once a year. Is there a limit on how much it can increase by?
No, there isn't. The Tenants Union would like there to be, and we are still trying to convince government that there should be some form of reasonable price control in the tenancy market. But the situation is there is no limit on the amount that rent can be increased to with a rent increase notice. However, tenants can apply to the tribunal for the tribunal to find that the increase or the new rent is excessive and set a rent according to the evidence that they're presented with. It's an application that we hope tenants will make more often now that no grounds termination is not available. Because people used to get no grounds notices because they tried to negotiate about a rent increase or they applied to the tribunal about a rent increase.
We had a follow-up question from the audience on that one. It says, currently rent can be raised to an unlimited amount, which we've just discussed, that's not the case, but currently rent can be raised to an unlimited amount when a rent rise occurs in New South Wales. What plans are there to change this?
The Tenants Union plans to get it changed, but we are faced with a government that is not friendly to that idea at the moment. There doesn't appear to be any willingness in the New South Wales government to look at a reasonable price control in the tenancy market.
I suppose a comment from the audience that there's a concern that contesting an increase by notice is an extremely drawn out and costly process.
It will cost you the application fee, and it may cost you other things depending on what sort of evidence you're looking for. It will take time. It probably won't be heard on the first occasion you go to the tribunal. There'll probably be a hearing set up at another time after directions have been made and evidence has been exchanged. And we think that the process is too difficult because the onus is on the tenant to prove that the increase or the new rent is excessive when it should be on the landlord to demonstrate that price rise is reasonable. But that's the way it is at the moment. But there's some help available. The Tenants Union has a thing called Rent Tracker on its on its website. And if you just search for the word tracker on our website, you'll find there are two tools there. One is just for information, and the other one will produce a document based on actual rent statistics that you can use in your negotiation with a landlord or agent.
There are also tips on the website about how to negotiate with your landlord if you're in the unfortunate position of having to negotiate a rent increase. So if we're not talking about limiting rent increases by amount, what kind of limitation are we talking about here, Grant?
There's two rules. One is the first year rule that says when you start your tenancy, you can't have a rent increase for a year. And then the other rule is called the once a year rule. And after the first year, you can't have a rent increase more frequently than once a year. And this is a great improvement because during and since COVID, we have seen a much higher frequency of rent increases in New South Wales. Agents and landlords use their market power to have tenants in and out of fixed terms repeatedly so that they could get 3 or 4 rent increases a year. And of course, tenants who challenged them by going to the tribunal were vulnerable to no grounds termination. They were disposable.
But now if I start a 6-month agreement and then that's followed up with a second 6-month agreement, the landlord can't put up the rent in the second 6-month agreement.
No, that's right. That's covered by the first year rule.
Okay. Knowing legislators though, there's an exception to this 12-month rule, right?
Yes, there's what's called excluded agreements. So fixed terms less than 2 years in length that were entered into before the 13th of December last year don't have the once a year rule apply to them until they have finished. And the first year rule doesn't apply. The once a year rule does apply, but the once a year rule has total amnesia. It does not remember or see rent increases during that fixed term. It only looks forward, so you can have a rent increase the day after your fixed term ends, but then there can't be another one for a year.
Okay. And then when the landlord does put up, like if they decide to put up the rent, how much notice do they need to give tenants?
They have to give 60 days notice in writing, and tenants have 30 days to apply to the tribunal for the tribunal to decide whether it's excessive or not.
Okay. I've got a question. Is there any consideration being given to the impact on the tenant, for example, financial hardship, rather than just market rent movements by NCAT when dealing with appeals against excessive rent increases?
No, there's not. And the Act expressly says the affordability is not considered by the tribunal.
Another slightly tricky one. If you have a contract for your lease with a set amount of time and the property sells, is the new landlord able to change the rent amount within the original contract?
No, the new landlord will become the owner and they will be subject to the existing tenancy contract. So the rent for that contract or the rent increases or a rent increase built into that contract will bind the new landlord, and they won't be able to have a rent increase until that fixed term ends.
Okay.
And then the once a year rule will start again.
All right. Thanks, Grant. And you're doing so well with all these rapid fire questions coming at you. Let's talk about fee-free ways to pay now. We've been talking about rent, and it's worth mentioning that renters now have a right to pay rent without incurring extra fees. What's that about? Why did that come into play?
In the 1990s, there were third-party rent payment services that suddenly came into existence. And they were folks who, for a fee, would take money out of your bank account and put it in the real estate agent's bank account. And a lot of tenants, when starting their tenancies, felt that unless they signed up to the agent's preferred rent payment system, they wouldn't get the tenancy. So then they were stuck with a third-party provider in some cases, and paying fees. And the fees, when things didn't go wrong, were fine. Well, they were low, a couple of dollars a time. It might be a service some people want if they, never want to have to bother with paying the rent themselves. But when it went wrong, there were default fees, and so people would owe a third-party provider a whole lot of default fees, and that money really would be much better off in the rent account rather than being siphoned off to somebody else. So it wasn't in the landlord's interest, and it wasn't in the tenant's interest, and of course it went wrong more often in the bottom of the market where affordability is more difficult. And so now tenants will have to be offered centre pay or bank transfer, and they can opt to move to either of those during a tenancy, whatever the manner and form of rent payment is that they've been using already.
Right, so that's really good to know. There's a free way available for renters to pay, and they have to be provided with that. Another little one I wanted to touch on was background checks. In the past, renters have been asked to pay for their own background checks when applying to the property, but I hear that's changed now.
Yes, there was this notion of a tenant profile, and that you could complete your tenant profile by having a background check done, when in fact exactly the same thing was being done by agents when they were looking at prospective applications anyway. So it was money for nothing really, and it's now been prohibited. So tenants should not be paying for background checks into the future.
Okay, excellent. Thanks, Grant. And I'd like to move on to pets, but just before I do, there's another short question, and it's to do with ending the tenancy again. If the landlord purchased a house and there's a tenant still living there 6 months in, can the new landlord evict the tenant, or are they bound by the 1-year contract that was existing before?
Where premises are sold with a tenant in a fixed term agreement, whether it be 6 months, a year, or whatever, the new owner takes the premises subject to that contract. So yes, they're bound to that contract, and they at the end of that contract, it either becomes a periodic agreement, or they sign the tenant up for another fixed term, or they use one of the grounds that's available in the Act to end that tenancy. And if, for example, if they want to move into the house themselves, then they use the, my family's going to move in ground and give a notice with the evidence that's required.
Okay, I think that's all we've got on terminations at the moment. Let's move on to pets. So there's another big change. It's that there's a new process for applying for pets in New South Wales. Grant, can you walk us through what that process is?
Yes, this makes a difference for people who are already in a tenancy. It doesn't make a difference for people who have pets and are applying for tenancies. That the problems with that will continue. However, there is now a process where a tenant can use the required form to seek consent from the landlord to have a pet at their place, and the landlord must respond within 21 days if they don't want it to just be deemed consent, so assumed consent. The landlord can decline to consent, and the tenant can apply to the tribunal, or the landlord can give consent with conditions, and the tenant can apply to the tribunal if they think the conditions are unreasonable. And the Act and the regulations really try to narrow down the sorts of disputes that can be had about this process by being very prescriptive about what it means and what the conditions can be and what are good reasons for declining consent.
And I'll ask you about those. So landlords don't have to agree to having a pet, but what are the reasons that they're allowed to give to refuse a pet?
There are, I think there's broadly two. One, it's about the premises not being suitable for that particular animal, or it not being possible to keep the animal humanely there. So another one is that there's a genuine likelihood that the animal will damage the premises to a greater cost than the rental bond. And you can see on the screen, the landlord lives at the property is a reason. Illegal animals. So if you have a dog that's actually not a legal dog in the state or according to council rules, then they can decline. Or there can be too many animals, and the legislation has a limit to reasonableness of number of animals at 4, but that's not a hard rule. It allows for the absurdity that 4 goldfish would certainly be reasonable and 5 would not be.
Right. So say we've got the reasons that landlords are allowed to use to refuse a pet there. What about if a landlord agrees to a tenant keeping a pet, but only under certain conditions?
Well,
What conditions could be reasonable in those circumstances?
yeah, there's a set of conditions that are listed as reasonable, and the tribunal can decide whether they're reasonable if the tenant applies, and they include fumigation and carpet cleaning, although the legislation still says if needed. So for instance, if you'd had an animal that didn't have any fleas, then maybe fumigation isn't needed.
Right. So the condition has to make sense for the type of animal.
Yes. You don't get, tenants don't get to pay for carpet cleaning if their pet's a carpet snake.
Right. Okay. Maybe if we take it from the flip side, what would be an unreasonable condition to place on having a pet?
I think it would be unreasonable to have to keep outside an animal that it was not usually kept outside.
Okay. Thanks, Grant. I suppose like a pet bond wouldn't be an appropriate condition to place on having a pet either, or asking for additional security.
No. Pet bonds have been illegal, I think, since 1977, and remain so.
Yeah, good. We've got a comment here or a question. Can a bylaw on specific pet laws circumvent this process?
Yes,
So
if you
want specific strict
yeah,
conditions.
if you live in a strata scheme, then there are two sets of rules you have to comply with. One is in the Tenancies Act, and the other lot is the strata bylaws. Now, a few years ago, there was a Court of Appeal case that said a blanket ban on pets in strata bylaws was not lawful, but it is open for owners corporations to make bylaws about types of animals. They can't make a blanket ban, so they might make a rule about size or weight of dog, for example.
Okay, so if you're living in a strata building, you'd have to be mindful of those bylaws as well.
Yes, you're after two consents there.
Okay. All right, so let's put this into context again. Aisha lives in an apartment with her pet staffy, Bruce. She wants a small second dog to keep Bruce company. What would you recommend Aisha doing in this situation?
Okay. Well, the first thing to say is if she has the existing consents to keep Bruce, then those consents live on through these changes. It's assumed that you have a consent if you had one before. So she doesn't have to go through the process for Bruce, but if she wants to add another dog, she needs to go through the application process.
Right. And if that response for keeping the other dog isn't favourable, is there anything that
Well, yes, the tenant can apply to the tribunal for an order that the landlord consent, or vary the conditions if there were conditions put on it.
Right. And we have resources on our website, tenants.org.au, as well about the tribunal and how to go about.
Yes, and I think this is a little bit like bond claims. The process is the answer. You don't know what's going to be the result. You have to enter into the process in order to find out.
Okay. We've got a few specific questions about keeping pets here. One of the people who registered for the webinar asked about approval for dogs in land lease communities. Can you shed any light on that?
A little. In a land lease community, and these used to be called residential parks, and before that they were called caravan parks. So in land lease communities, whether you can have pets is a matter of your contract and the community rules. So it's a bit like strata bylaws. If you own your own dwelling, then you're under the Residential Land Lease Communities Act. And if you don't own the dwelling, then you're under the Residential Tenancies Act. But the community rules will apply to both owner occupants and renter occupants.
Thank you for that one. There's another slightly more interesting situation as well, where we've got a tenant living in a granny flat or a separate dwelling to the owners. Does that affect their ability to have a pet on the property?
The process is going to be the answer. You would make an application, and the question there is, what are the premises? Because the landlord living on the premises is grounds for refusing consent to keep a pet. And so if the tribunal takes the view that the premises are just the granny flat, then the landlord doesn't live in the granny flat. However, if the tribunal takes the view that the premises include the shared yard, for example, the tribunal may find that the landlord lives there and can refuse.
Thank you. All right, so we've covered evictions, rent increases, fee-free ways to pay rent, not having to be charged for background checks, and pets. But there's another change that's come in recently, and it has to do with toilets, right, Grant?
Yes, as you can see on the screen, the old rules still work. So 9 litres per minute for those, those taps and showers, etc. But since 23rd of March this year, tenants don't have to pay for water unless there is a dual flush toilet with a minimum 3-star rating under what's called the WELS system. Now, that the 3-star rating has an average flush of, I think it's 4 litres. Yes, it's average flush of 4 litres, but the average is worked out over 3 flushes, one of which is the large and 2 of which are the small. So if people can't find, by the name of their toilet from the WELS website, that it's a 3-star or better toilet, then they can test it by flushing and measuring. For example, you do a half flush, and having measured the height of the water in the cistern, and then use a graduated jug to refill the cistern and measure to see if the half flush has actually only used 3 litres.
So if I do a test like that and it doesn't meet the efficiency standards, I'm not required to pay the water usage.
Well, your contract may say that you do pay, and the landlord may say that you're in breach of contract. And if you end up in the tribunal, then you're going to have to give evidence that convinces the tribunal, so that taking photos, some people would like to take videos, I presume, of the testing process is a good idea, and you can write a statutory declaration about the method and attach to it photographs and other documents.
Okay. Thanks. That's really interesting and potentially could save people a little bit of money. Okay, so today we've covered a few big updates to tenancy law. Some of the main takeaways are that landlords now need a legally valid reason to evict tenants, and they need to give the tenant evidence to show their reason's genuine. We have that rent increases are now limited to a maximum of 1 a year, and rent can't be put up at all within the first year of the tenancy. Renters must be provided with a fee-free way to pay rent. Renters can't be asked to pay for background checks when applying for a rental property. We also see there's a new process for applying for pets in rental properties. Landlords can only refuse for one of the reasons we talked about. And if they agree to you having a pet, they can place reasonable conditions on that pet ownership. And rental properties now have to meet certain water efficiency standards, including having a dual flush toilet. Grant, if a renter isn't sure how the new rules apply in their situation, where can they go for help?
They can look at the stuff on the internet, on the Tenants Union's website, tenants.org.au. They can also look at Fair Trading's website because the stuff's there, and if anybody's got an appetite for legislation, they can look at the legislation on the government website or on AUSTLI, AUSTLII.
Right. There are also tenants advocates available for people to speak to if they'd like to walk through the issue or if they're not sure how the information applies to them. You can find your local service by putting your postcode in tenants.org.au and you'll get their contact details. We've got a few other options available there as well. The Tenants Union advice line operates 2 times a week, and we also have the contact details for Fair Trading there. Now, we have a few minutes and there were a few questions in the chat that I'd really love to cover. If you haven't yet put your question in the chat, please go ahead and do so now. But Grant, there was a bit of confusion from a number of people about the end of a fixed term agreement. I suppose because it's changed a little bit. A 6-month agreement, can that be followed by another 6-month agreement as well, or will it have to go into a periodic lease?
No, it doesn't. It doesn't have to. If you don't do anything, it automatically becomes a periodic agreement. But it's open for the parties to sign up to another fixed term, and they can negotiate how long that is.
But that can only end on one of the grounds, is that right? It doesn't just
Yes, that's right.
period.
It can only end on one of the grounds.
Okay, thanks, Grant. Have a question here. Can owners use the grounds to evict a tenant during their fixed term lease, or do they have to wait until the lease has ended?
Some of the grounds can be used during a fixed term. For example, breach, and what else? Oh, uninhabitability, hardship. So nothing's changed there. But most of the new grounds need to have the agreement ending at the end of the fixed term or after.
Thanks, Grant. I'm scanning this now for a few questions. Oh, is there a minimum amount of rent arrears or a minimum time frame that rent needs to be outstanding before a tenant can be evicted?
Yes, the rent arrears has to be of 14 days. So you have to be adrift 14 days for the landlord to be able to give a termination notice.
You just scan and make sure that we're answering everyone's questions. Advertising for no pets in an advertisement for a rental property, is that allowed?
I don't think so.
I have to check back on that one.
I think that's been prohibited, but I haven't got it right to hand.
Okay. Landlord had bad experience with pets damaging rental. Is that grounds for refusing pets? Like, I suppose prior experience of a pet damage.
It's no, it's not. It's not among the listed grounds. So the landlord may think then that the tribunal should agree with them that the proposed pet is likely to do damage greater than the bond, but that's a matter of evidence that convinces the tribunal.
Okay. A few now on the sale of property. Can that end a fixed term agreement?
Not of itself, no. Although we have seen cases where landlords who want to sell with vacant possession have helped tenants move by waiving rent or paying for removal costs. So it's open for the parties to agree that this will end, and so end a fixed term so that it can be sold with vacant possession. But no, sale of the premises to a new owner during a fixed term ordinarily gets a tenant a new landlord.
Okay. Back to rent arrears. If within the 14 days of unpaid arrears, and the tenant is, say, in hospital, can the tenant be given some grace time to pay the arrears?
There's no strict rules on that. The best thing to do is to get the rent account square as soon as possible, but certainly communicate. If you're in hospital and the rent is not going to be paid because you're there, then contact the landlord or agent who you normally deal with and let them know that there's going to be a delay. And, you know, make arrangements to pay the rent. Something we've noticed in the tribunal, it doesn't matter what the issue is, if there are rent arrears, it distracts people. It distracts the tribunal, which sometimes it shouldn't. But you know, my simile is that rent arrears are like a 2-metre long orange flame in the room. Nobody pays attention to anything else until it goes out.
Thanks, Grant. On that beautiful image, that's us for time. Thank you, everyone, for joining us today. I appreciate all of your questions. Apologies if we weren't able to get to yours, but thank you very, very much for joining us, and hopefully these new changes can bring about some good results for tenants.
Thank you so much, Charlie and Grant, for that great Q&A. And we know there are a lot of reforms and a lot of changes. And I just want to give another shout out to the Tenants Union website. If you just go to that website, there's a button on the home page that directs you straight to more information about the laws, and it's constantly updated. So definitely check that out. And another huge shout out to New South Wales Law Week and the Lunch and the Law series. Yesterday, we had a webinar on parenting arrangements, and that's now up on Legal Aid New South Wales YouTube page. There's been a lot of changes around family law that you can also be updated about. And again, our webinars for the rest of the week on buying used vehicles, on traffic fines, and on mobile phones. So thank you so much for joining us today. You will receive an email tomorrow with links and other resources. So again, huge thank you to Grant and Charlie, and a thanks to our Auslan interpreters for being a part of today. And have a great day and happy Law Week.
Thanks for having us.
Thanks, see
everyone.
ya.